Good afternoon, everyone. Let's go ahead and get started. I got a message from Shelley. She is not going to be able to join us today. But I do want to get rolling, hopefully keep this meeting to just 1 hour. I did not circulate an agenda, but just to kind of go off top of what I want to cover, today we're going to be talking about the memo that was created by Stephanie Durier, who is on this call today. Stephanie obviously is from CSG. And there's some issues in the memo where Stephanie proposes, based on research gathered by CSG, some considerations to address when we're looking at the possibility of dual supervision. So anyway, just to get the meeting started, we'll go ahead and take roll in just a moment. I'm John Francis. I'm chairing this committee, and let's just go on down the line. And Robin, do you want to call roll, or do you want to just go through? Or Natalie, I'm not sure who will be doing that.
Hi, Professor. This is Natalie Nelson. I think it's easiest if everyone just introduces themselves.
Okay, that sounds good. Thank you. Secretary Zamuda, you're next on my screen, so why don't you just go there and then we'll go on down the line.
Good afternoon. This is Jeff Zamuda, Secretary at Kansas Department of Corrections.
Thank you. I see Representative Owens is on the call right now, too.
Correct. Representative Stephen Owens, 74th House District. I am present.
Okay, and I see Sheriff Carr is on the call.
Sheriff Carr, representing KSA.
Thank you, Sheriff. And I see Spence Cohn.
Spence Cohen with Office of Judicial Administration.
And as far as members of the subcommittee, have I missed anyone? And we also have some folks who are not members of the subcommittee, but are with us today. And Stephanie, can you go ahead and announce yourself?
Absolutely. Good afternoon, everyone. I'm Stephanie Durier with CSG Justice Center.
Okay, thank you, Stephanie. And I see someone, and I don't see that name anymore. I saw a name, Murray Vidal, I think.
This is Merle Riedel with Legislative Research.
Oh, Merle. Okay, I'm sorry. I was, yeah, the text was real small and it looked like MURI on my screen. So my apologies, Merle.
No worries. I've been called worse.
All right. So what I want to do now, well, first of all, let me just toss it open to any questions or comments based on the memo that that Stephanie created. This was a memo that was circulated to us by Natalie on September 13. I hope you've all had a chance to look at it before we begin today. But before I turn it over to Stephanie, are there any questions or comments that folks want to talk about? All right, hearing none. Stephanie, I'm going to go ahead and toss this over to you and ask you to lead this part of the discussion.
Great. Thanks, Professor Francis. I hope everyone is doing well. It is a rainy and overcast Monday here in Washington. So I am, forgive me if my teeth chatter, I am very cold this morning, to say the least. I really wanted to talk to you guys today about a couple of things. I wanted to talk about the memo Professor Francis mentioned, and I also wanted to update this subcommittee on the conversations that we've had with chief CSOs throughout the state over the course of a few focus groups that were held over the last couple of weeks. And also to let you know that we will be holding this focus groups with the directors of community corrections this week. We have 4 planned for this week where we'll be covering the same topics with them. So to give you a little bit of an update on the focus groups, I'll start there because I think that'll be helpful. We asked the chief CSOs for their feedback on really 3 different topic areas: dual supervision, the conditions of supervision, and the um, uh, I'm blanking on early discharge. Spence, I'm looking right at you and going, Spence, what do we call that subcommittee? There's 6 now at this point, and I'm starting to lose all of them blend together. So we covered those 3 supervision topics with the chief CSOs, and really the most pertinent one to obviously this commission is the dual supervision one. What we heard is that it is a problem. So yeah, the districts that participated reported that their caseloads that are dual supervised fall between 5 and 10%, most likely. 15 seemed pretty high for them. And that most dual supervision occurs between court services and community corrections. The most common challenge that we heard, or the most common challenges that we heard, was that there's a lack of communication between court services and community corrections in the various districts that we talked to. For those districts that are lucky enough to have court services and community correction housed in the same building, those communications aren't as prevalent. But for those districts that have them housed separately in separate buildings across town, or maybe even in different counties, it is a problem with officers lack of communication on dual supervised cases. The other major problem or challenge that we heard was the inability to enforce, or the lack of enforcement of certain conditions that may be, for instance, a court services condition, but community corrections does not enforce it. So probably the easiest example, and I believe one that you may have heard before from us, was that of any fines and fees related to court services supervision. It's creating a situation where someone may be supervised for their term with community corrections, but because they have these fines and fees left over, they're placed back with court services, and oftentimes with no information on what took place over the course of the supervision period, which really puts court services at, not a great place to understand what that person has done over the last 6, 12, 18, however long that supervision period was. Of course, that's coming from the chief court service officer's point of view, so we'll get some more information from community corrections point of view this week, report back to you all. What we plan on doing with that information that we've collected is to actually create a formal summary for everyone. Unfortunately, we have to go through our BJA report process, which means that we'll just be a little delayed in getting all of that information to you in a more formal way than a verbal reporting out that I'm doing here. But I think that information really lends itself well to the document that Professor Francis brought up that was circulated by Natalie on our behalf. But I want to pause there and ask if there are any follow-up questions on the focus groups and anything that we heard, or questions that you may have on any finer details.
Stephanie, I have a question. Can you just describe who took part in these focus groups? How many people were we dealing with? What parts of the state were they from?
Yeah, it's a great question. So Spence really was amazing and really set up these focus groups for us. So much appreciation goes out to Spence. We held 4 focus groups, and we had folks from across the state. So we had rural districts represented, we had urban districts represented. A really great way to exemplify that was that we actually had a chief CSO join us from the Kansas City area. And so as we went around during introductions, I asked what how many people the chief supervised, and it was 4, it was 5, it was 3, and then we get to him and it's 31. And I was like, wait, where are you in the state then? Because that's a lot more officers. So we had some really great representation from across the state. All chief CSOs, including the 2 chiefs that actually function as the director of community community corrections in their district as well. So it was great to hear their perspective. And I think in total we had 14 chiefs participate in those focus groups.
Thank you. One of the questions, were the focus groups exclusively, one group was court services and the others were community corrections, or were they mixed together in a single focus group?
So all the focus groups that have been completed so far are with chief court service officers. The community corrections directors will be completed this week. So we haven't talked to anybody from community corrections yet, outside of obviously those folks that are here on the subcommittees that we speak to through the commission's capacity, which is Shelley Williams and Randy Regar. I'm not sure if I said his last name right. So those are kind of our only two community corrections contacts at this point, but they by no means participated in a focus group or have we covered these topics with them specifically.
Okay, thank you.
Sheriff Carr, do you, within the focus groups, did you ascertain the level of clientele that the directors were seeing?
So are you, just to make sure I understand your question correctly, are you asking the level of clientele that the chief CSOs are carrying themselves as their caseloads?
Yes.
Okay, so not every chief CSO is carrying a caseload. Really great question. In the rural areas, your more rural areas where you're covering 6, 7 counties with only 3 staff members, the chief CSO is carrying a caseload. Most often what was described to us was it would be their PSI cases, it would be banked cases. In a couple of circumstances, they were cases that they've actually brought with them from being a court services officer to being chief court service officer. So that person has just been on probation for so long that they've just continued to carry them. In a couple of cases, they did mention that if they have someone who is of notoriety in the area, a lot of publicity has been around their case, they'll take that person on in particular. And then a couple others also said that they'll take on kind of quote unquote the problem children, those that may need a little bit of an extra hand in their supervision case.
Okay.
But not every chief does carry a caseload, just to make sure that's clear.
Okay. No, and then I guess if you're looking at doing the same type of study for the community corrections, I'd be curious, the directors that are and associate directors that are carrying caseloads, at what level are doing. And Spence, you're gonna have to help me. Level 1, 2, 3, and 4, I think, 1 being the worst.
Yeah, I'm not sure how community corrections does their level, so I can't speak to that, Sheriff.
I just recall level 1 and 2.
Right.
Ones are the ones that are reporting 3-4 times a week, and then I think it's 4 and so on, or maybe once a month or every other month or something. I'd be curious to see what level.
Absolutely, Sheriff. And we, I will say, I did not ask that question directly of the chief CSOs, but from their responses, they are not cases that they see once a month even. That it's much more spread out than that. So it would probably be your lower level. We definitely can include that in the conversation with the directors of community corrections and ask about what kind of caseload they're carrying. We do ask them what the average caseload of their staff is, to kind of get a sense of what they're dealing with in their districts. But we can definitely incorporate that with the directors.
Okay. Sorry, Jeff, I didn't think about having Zamuda on here, but I just know there's several levels, and then obviously the frequency of seeing the clients, and then those who, as what we're talking about, that may still be on just for lack of payment and sort. So be curious as to the levels of the clients, and I think that would help the group as well.
Absolutely.
Yeah, and we could, this is Jeff Samuda with KDOC. We could ask, I could ask Hope to get us those and I can distribute that, Sheriff, if that'd be helpful.
Yeah, I don't know. Like I said, a very, very diverse group of individuals on here. So knowledge is power. And I think if we can gather all that while they're doing this study, I think it'd be good for everybody.
Absolutely. And Sheriff Carr will definitely include those stats in our report. So on average, how many cases or what the caseload size is of the officers in each district, according to the chief of that district and things like that. So we can give you an idea of, kind of what they're dealing with across the state. And when we look at communication and challenges that they're facing.
Much appreciated. Thank you.
Yeah, definitely. All right, well, I'll pivot to the document that Professor Francis brought up. It's titled Consolidation of Concurrent Supervision. We can replace concurrent with dual. I think at that point we hadn't settled on this subcommittee name, so ignore that kind of title. Please feel free to replace it with dual. Really what the purpose of this document was to really just provide a framework for this subcommittee to create some process, some procedure around dual supervision. It is not an end-all be-all, as we described to Professor Francis last week. This was based on a couple of different things. It was based on Jennifer Castilla's notes and observations from conversations that took place last year during the commission. It is a combination with the juvenile dual supervision legislation that's already passed in the state. So you'll see some wording in there that may look familiar. And it's based on what we've kind of heard from what you guys would like to see this time around, or address challenges that we've heard this time around with the commission. And so we can kind of move through this section by section. So by controlling case here in the first section under proposed guidelines for consolidating concurrent supervision cases, controlling case really means who has control over the case at that moment. So what court has control over that case, and thereby which supervision agency is controlling the case. So Professor Francis mentioned that number one here, we can probably just remove, let's not address municipal. He had a great point. We don't have anybody from the municipal system in the commission, I don't believe. So that's a great thing. We can strike that, not a problem at all. And then one of the conversations that we've had but got halted was between district courts or between court services and community corrections. We can think of it in different ways, and both are appropriate, really. The longest possible sentence is controlling. So how do you guys, as a subcommittee, how would you like to think of who is most appropriate? So obviously, community corrections is supervises, your felony probation and things like that. Court services is more for misdemeanor probations and lower level felony probation. Spence, definitely correct me if I'm wrong in that kind of general statement there. But who has the authority in that dual supervision case? What makes that decision is really what that number 2 is meant to do. How would you guys also, let me elicit, would you like to move through this entire form, and I can just do a shaking of the, nodding of the head? Would you like to move through the entire form and then circle back, or would you like to pause at each one?
Stephanie, what I'm going to suggest is a general overview, and then let's kind of circle back and take a deeper dive into the issues. And that way we have the full picture before we start talking about individual components of it.
Sounds good. So the third point there is really if a new sentence is placed on someone who's already on supervision. And then number 4 is what to take into consideration beyond that. So the residency of the person, the ability of the person to travel, resources for residential and non-residential sanctions, for treatment that the court may order, things like that. The next section there is around financial obligations. So this is really trying to respond to some of those things that we heard that were a challenge between court services and community corrections around fines and fees, enforcement of collection. We're by no means suggesting that community corrections should be responsible for collecting on behalf of court services. That muddies the waters too much, probably, and probably would make things pretty difficult for, accounting departments across the state. But how could they possibly enforce that, whether that be through requiring that they are submitting proof of payment, things like that? So how do they coordinate on some of those financial obligations? And then around the conditions of supervision, there's some language here around sanctions. Who is informed when a sanction occurs? If somebody is sanctioned on community corrections, at what level should court services be aware of that sanction? So if it changes a curfew time, if it increases the number of UAs that need to be done, obviously if there's a revocation process taking place. And then termination of supervision is the next one. And that really is just saying you should really create some language around who informs who when there is a termination of supervision. So making sure that either agency is informed. And then some language there around KDOC and what that may look like when there's concurrent supervision with parole. And then finally, that final section is just considerations for the subcommittee. So some questions for the subcommittee to answer when we're moving through some things around when we're talking about control of a case. What are things that we need to consider, like the risk assessment system in the state? So the LSCMI, it actually doesn't matter what risk assessment you're using, but they require that somebody undergo a reassessment. They're only good for usually 6 months to a year. And so at what point and who's going to be responsible for administering that risk assessment follow-up? Who's going to share that? Who's going to complete discharge summaries, that sort of thing. And then conditions of supervision, again, some questions around how to have more consistent conditions of supervision. And then finally, and I know I'm going pretty quickly here, but finally, KDOC and concurrent supervision. This may not be a big deal at all. This is me as someone who's not an attorney, pointing that we do have some language in statute in Kansas around concurrent versus consecutive supervision sentences in the state. So just making sure that we're in line with the language already in use or in statute. And I'll pause there.
Natalie, I'm sorry, Stephanie, I have a question, and I preface this with the observation that I probably have less day in, day out understanding of how these issues play out than anybody else in this room. But one of the things that I think drives a lot of legislative decisions may be budgetary impact. And so if there was a decision eventually to decide that in dual supervision, we would look to a metric like length of sentence, based on what I've been hearing so far, I'm assuming that it probably increases the likelihood that community corrections would be overseeing some of the, more of the dual supervision situations. And they might be doing that for some cases where somebody's also being supervised or would otherwise be supervised by court services. So what would be the financial impact on community corrections? Will that be a greater outlay, or is it going to be a situation, well, they're already supervising this person, so it might be a little bit more, but not a lot more? And then also, what's going to be the impact on court services budget? Is there going to be a beneficial impact? Is there going to be an impact where there's concern that maybe some of their work is being poached from them? And so just I'd like to kind of delve into what are some of these issues that might play out.
Yeah, Professor Francis, these are great questions. Unfortunately, I probably am not the best person to answer the financial impact on the system. I would probably lean on Spencer, Secretary Zamuda to kind of field those types of questions. I can tell you from a resource point, anytime that you are reducing duplicative services in the state, you're going to save on resources. So staff time, especially, and in the supervision world, staff time is really one of the biggest concerns around resources, especially when you're in a district with 3 court service officers and everybody has 80 to 100 people on their caseload. Anytime that we can reduce the effort they're putting in, that mirrors the community corrections effort is beneficial for court services, as long as court services is being made aware of that, aware of what community corrections has done, that court services would also kind of enforce as well.
Well, this is Sheriff Carr. I know, and Secretary Zamuda, I think you can chime in on this. Being on the board of community corrections, I know some of their funding is generated off of programs. So I don't think there's as many programs under the court services side as there are through corrections. So Spence, I can chime in on that. But I do see that as being a topic of discussion for finance purposes.
Yeah, I'll say for court services, we don't our budget isn't due to population. So if we lose 10 people, that's not going to affect our how our budget works. So I think it may affect community corrections more than it would us.
This is Jeff Zamuda. Through a grant process, KDOC provides a pretty substantial amount of community corrections operating budget. And so if we saw an impact where more programs needed to be delivered, they had more people on caseloads, we probably need to adjust funding for that. To ensure that they had enough funds to deliver that. I don't know if I don't know how much it's going to impact them. Spence, could you just, maybe you've said this to us before, but just refresh my memory, your sense of it, and I'm putting you on the spot here. Would your sense of it is if we went to longer terms of supervision, the entity that had the longer term, would that fund, your sense, would that funnel more people to community corrections and court services? Do you have a sense of that?
I think I'll rely on what Stephanie said earlier. I think with her conversations, it sounded like 5 to 10% of those people may have community correction sentences also. But I guess then it goes back to how funding is done. Is it per person or is it per case? Because if community corrections is already supervising that person, funding wouldn't be affected because they're already seeing them. If it's per case, which I think my personal opinion is it makes more sense to be funded by person. And maybe I'm off base with that, but my general thinking is that shouldn't affect then the costs.
This is Sheriff Carr. Even at the 5 to 15%, I wouldn't see that as being a really an impact on any budget in reality. Just even on program fees. Now, Shelley's not on here, is she?
Mm-hmm.
Okay. And Secretary Zamuda, I don't know if there's any consistency across the state, even when it comes to program fees from community corrections from each region to the next either. Do you know?
This is Jeff Zamuda. Yeah, I don't know, Sheriff. My sense is we have provider contracts set up to the extent possible. I don't think they're in every county to try to kind of level that out. And we just adjust grants based on the requests we get. So if we saw a spike, we'd have to do some adjustment there. And of course, at some point, it might take a little additional funding. But I agree that 5 to 15%. Theoretically, probably shouldn't increase that a lot of need if they're already on supervision. Can't imagine it'd be a lot, but we'd certainly adjust it if a county came forth and said, hey, this is really impacting us, then we need to look at adjusting it.
This is Sheriff Carr again. I guess one of the questions maybe for your next survey or study would be who has programs, who charges for programs, and I'm not even certain the program fees, if it's a budget item or if they're using them for other, I don't know, expense wise, what they're being used for. So that may not affect what you're talking about, Secretary Zamuda.
Yeah, it may not.
This is Stephanie with CSG. So a couple of things here about programming. And Spence, I think that we've had this discussion before as well, is that court services and community corrections in districts where there are more community corrections resources for programming, court services and community corrections has worked really well in getting people into programming if they cannot afford to finance programming on their own. So in court services case, they don't have that grant system of, you know, programming that they can offer.
You cut out on it, Stephanie.
Sorry, folks, can you hear me now?
Yeah, you froze up there, and we did get a low bandwidth signal there.
Sorry about that. I'm going to keep my camera off and hopefully that will help a little bit.
Sure.
So what I was saying is that community corrections and court services, when there is someone who needs programming, have worked well together from what we've heard to get someone into a program that's accessible in their district. So I don't necessarily see that as being a large financial burden. More so, I believe the impact may be in how different judges in different districts kind of view this dual supervision role, since they can ask that court services or community corrections supervise a certain case.
So any other questions for Stephanie about that topic? I'd like to circle back to point number 2 on the memo under controlling case, and that is the suggestion that between district courts, the longest possible sentence is controlling, and I'd like to get people's input on that, whether that, you know, based upon your experience, that is the metric that makes the most sense. And I'd like to toss it open for discussion on that.
This is Spence, and just to be clear, and Stephanie, I assume when you're talking sentence, you're meaning the controlling prison sentence, not the probation term. Is that correct?
Yes.
Okay, thank you.
This is Sheriff Parr. I guess a question I have, do we have any district judges part of this discussion? I'd be curious to see what their take is on determining the sentencing side of this for probation or parole.
This is John Francis. We had tried to get some district judges on here, but we were unsuccessful in getting them into this subgroup, so we don't have that insight. But I agree. I think that is important insight, you know, to get their perspective on what would be something important to consider.
Yeah, given what Stephanie's pointed out with the statute having the consecutive and the concurrent, obviously that's going to come from the bench. So I don't know how this subcommittee would go about, I guess, wording the questions and maybe sending it out through OJA and getting a feel from them. I'm curious to see what their thoughts are.
Yeah, Sheriff Carr, this is Stephanie with CSG. So we are attempting to engage the judiciary on these similar topics. We've had a little bit of a tougher time kind of nailing them down, of course, because they're in court and have all of their commitments. But this was definitely on our radars as something to talk to them about around their decision-making process. when it comes to deciding on dual supervision cases. And so I think if we are not able to engage them kind of with a focus group and we could maybe survey them through OJA, I will offer that we would be happy to collaborate on survey questions.
This is Sheriff Carr again. I think Spence could probably speak on this, but I know at least in our area, our judicial system's very good about listening to the probation and parole officers on recommendations and suggestions too. So their thoughts on it, and then obviously we're going to look at the prosecutors and defense bar recommendation as well, I think.
Any other thoughts about this question of using longest sentence as the controlling factor?
Professor,
I
this
will
is
just
Jeff.
say,
Oh, go ahead,
Jeff.
Spence. Go ahead, Spence.
Okay. All right. I was just going to say, just for those, if you guys aren't familiar with the sentencing grid, you know, so the longest sentence is generally going to be your higher level felony. So, you know, for instance, a level 10, a 10 with, you know, non-person felony might be a 6-month sentence, whereas a level 7 with a one non-person felony is a 16-month sentence. So the higher risk or the higher you get on the sentencing grid, the longer the sentence is. And I would say typically, and this isn't standard across the board, but when we're doing risk needs assessment, the individuals that have the higher risk felonies are usually the ones that end up, I'm sorry, let me restate that. The ones that have the higher severity level felonies usually end up higher risk. It's not across the board by any means, but once you get, you know, when you've got several felonies, that bumps up your criminal history and you usually score out a little bit higher. So those end up with community corrections generally. You know, my 2 cents is as an officer, I always thought it made sense if I had a new case from a PSI that case and it's already on community corrections should just be assigned directly to community corrections rather than court services, as they're already doing supervision with that individual. So, you know, I know that there are judges that will still put them on court services as it's still based on risk and those levels. But, you know, just to give a little perspective of how the sentencing grid works if you aren't aware.
This is Jeff Samuda, and I guess my question would be, if we didn't go with the longest possible sentence being controlling, what would the default be? What else would we use as the determining factor? I mean, it seems to make the most sense to have it be the longest possible sentence, but I'm just trying to think what else would we use as a default?
This is John Francis. So in the past, we have talked about the risk assessment, but it sounds from what Spence is saying that in most, maybe even all cases, the higher severity offense, which would have the highest sentence, would correlate to the highest risk assessment too. That's just not necessarily that one is causing, but that's just where there's going to be a concurrence of the factors coming together. But I think there could be an argument that for those rare cases where maybe a higher sentence wouldn't correlate to a higher risk, to go with the risk assessment. But I think that's the other metric that I could see being used. Stephanie, has your research addressed that question of risk versus severity?
I don't necessarily think that there's research out there that says one or the other. Risk always, should be involved in the decision-making process in the supervision case as to, the severity of or the intensity, I should say, of supervision. But I would say that one thing that I would open up to the group is that not only is it looking at sentence length, but also how to approach it when, and perhaps this works itself out naturally in the state. I can default to those in the state. When someone is currently serving a community corrections probation, picks up a new charge that would normally be a court services charge and extends out that length of probation period. What does that look like when there's going to be some dual supervision on that with court services? Extending that probation out. So if a judge would like to put them on probation for a year, but they only have 4 months left with community corrections, should it be that specifically stated that it would come back to court services, or that it should remain with community corrections because they do have that existing relationship? We do know the research says that, relationship building on supervision is hard, but it makes a huge impact on successful outcomes.
Well, this is Sheriff Carr. I can tell you from my years of experience, clarity is good in the statutes. So the courts, if they can read it and it's black and white, it seems to go a lot quicker.
I agree.
So a question I have, again, I want to toss it out to the folks who are really doing this, is from an outcomes perspective, does it make more sense to keep the person with the same supervisor? Or if there's a situation where, the example Stephanie just gave, where the term that originated under community corrections expires and there's still a residual sentence left for court services, would it make sense for the person to transfer their supervision to court services or continue out that court services component, still being supervised by community corrections?
This is Sheriff Carr. I mean, this is definitely up Spence's alley, I think, and Shelley, if she were here, but no, my wife did it for 16 and a half years, and clients, they do get accustomed with their probation officers and they build that relationship and trust. So, I mean, I don't see it as being good to start transferring from one to another in the middle of the case. So just my 2 cents on that.
This is Jeff
Yeah, so-
Sabuda. I agree with Sheriff. If there's a way to keep that continuity of supervision, I think that gives that person the best opportunity for success.
So just my 2 cents. I like the idea of the continuity of supervision, but I guess where I question this a little bit is, say you have someone that's on, and I've discussed this type of scenario before. They picked up 2 cases at the same time. One doesn't go before the court until almost a year later. And so the longest controlling sentence is the previous one where they're on community corrections. There's a reason they might be placed on court services for the second sentence. Maybe, they were 1 point off from community corrections or court services on a risk assessment. And then they've got, 10 months left for court services. Does it make sense to keep them on a high risk supervision when there's a reason that the court may have placed them on court services probation? So I wonder, is there a caveat when we write up the policy with, if there's 6 months or more of supervision remaining, or I'm just throwing out an arbitrary number, this isn't my idea, but 6 months or more of probation, then it goes to the highest sentence. If there's 3 months left when the new case is placed on, then it goes to the case that it was assigned, or it gets transferred back for the remainder of that supervision. I'm not wording it very eloquently, but that's just kind of my thinking.
Yeah, this is John Francis. Thank you, Spence. So I think I understand what you're saying, which is basically if somebody on one case had a higher level of supervision, needed more services, they complete that sentence. There's a remaining sentence where the person, wasn't sentenced to those higher levels of supervision, does it make sense to continue supervision at that high level of supervision? Do you have a sense of how often that might occur?
Boy, you know, that's hard to say. I mean, you often see cases that get, you know, drug out, strung along for a long time before they get sentenced, or say maybe they've been in DOC for a while and then they're getting out and then they finally come back if they haven't done their writ and come back before court and been sentenced. So there are instances that does happen. And I guess my thinking is I would hate, you know, I think it makes sense to keep it with the higher supervision level. I like that idea. But there are going to be circumstances where maybe it makes sense to transfer to court services after a month or two of supervision and when that first supervision ends.
So I have a thought that, and I'm really just thinking off the top of my head right now, at the risk of undermining Sheriff Carr's observation that clarity is good, and I agree with that, by the way, Sheriff Carr. Clarity in statutes and clarity for the courts is good. If this was written up in a way where basically the default would be sticking with whoever is doing the supervision, and that would typically be the higher level. But that, so have that as the default with a caveat that unless the court orders otherwise. And I don't know if that's introducing too much ambiguity in, but if there's a suggestion that, you know, all things being equal, we'll keep the person in the same supervision unless there is a reason to transfer once one expires.
This is Sheriff Carr. I'm not disagreeing with you, but again, being around this as long as I have, and Spence, you're already grinning. Starting to step on judges' toes can be a ballet. So I don't disagree at all, Professor Francis, because we know there are circumstances and situations that arise. Just, I guess, who do they turn to for clarification?
So that's a great point. And actually, part of what I was thinking was that it would be, you know, that the case could go to the sentencing court to reevaluate at that time, maybe. And you know, courts might not love that because it could potentially clog up dockets. But it sounds like we're dealing with a small number of cases too. This isn't something that is likely to cause an actual impact on daily dockets. It sounds like it would be kind of the rarity for that to happen. And maybe something should be written in that just places, you know, gives the court the option to revisit that question of who would do the supervising then.
Spence and Secretary Zamuda, the way I'm reading this, or kind of understanding what Professor Francis is saying, is kind of similar to the Senate Bill 123 program. I think if you have somebody that, I guess, specializes in this and has a clear understanding to help guide them through the process, am I hearing it wrong or interpreting it wrong?
I was gonna let Secretary answer that one. I'm not. I guess I'm not, and I'll tell you why, Sheriff. I'm just not real clear on how that correlation works. Maybe you could expand on that for me.
Yeah, well, I know with the Senate bill with the drug program, I mean, they have people through DOC that, I mean, they really understand how that law is written, and the courts rely on them, I know, heavily on some of these decision-making scenarios. So I guess that's how I'm seeing this, but to get there, we need, in short, we need the bar involved in this. Some of our discussions, getting them to the table, and Stephanie's, they're doing a great job in trying to accommodate that currently, but how do we get there?
Yeah, this is John Francis. Sheriff, I think that's a great point. And Stephanie, is this a question that you can try to solicit input, hopefully from, as you said, a focus group of judges, or if not, from OJA, I think if there's some overarching provision in here that sentencing courts shall retain jurisdiction over their cases, that would help with this. But I think that might still be a little bit too open and create some muddiness. And I really do agree with Sheriff Carr's point that clarity is going to be the best thing in any package of legislation that is proposed. I see we've got 9 minutes left before we hit 1 o'clock, and I don't want to prematurely end discussion of this topic, but I do also want to get some feedback for Stephanie on this question of limitations of one agency performing tasks for another, such as collecting fees. And so I'd like to move to that, but before that, I just want to ask if anybody has any other input that they want to give on this question of controlling sentence.
Professor, this is Jeff Smoot. Maybe one more, and I might be off base here, but if we accept the premise that there's not a lot of those cases that are going to be extended out, the scenario that Spence provided, maybe we could have a triggering mechanism where there's a case management process where if both entities come back to the court and ask that the transfer take place or something like that, where it could be staffed, maybe a simple mechanism there. And if no one comes forward and asks for a change, then it just remains as is. That would be the default, something like that.
Yeah, I think that's a great suggestion. And I think that would address the issue of the default would be keeping it where it is. But if everybody's in agreement that it should switch, that would be a reason to bring it back to the sentencing court, and jurisdiction stays with the sentencing court. I think it's a very effective way of addressing that.
And just have that be managed or initiated by the case managers.
Yeah.
If they don't initiate it, then nothing changes.
Hey, Spence, sorry, this is Sheriff Carr. Spence, do you have that statute off the top of your head, or Secretary Zamuda, that deals with the transfer of cases or from one jurisdiction to another?
I don't have it.
I know we discussed it in one of the other subcommittees last year, beginning of all this, and I'm thinking that might be the statute to look at, unless Representative Owens or Senator Haley can recall which statute that is. I know it was
Sorry,
looked at
not
legislatively.
right off. I used to be good at these things, but sorry, I don't recall right off.
I know it was a brief discussion in the legislation last year or the year before. I don't have it in front of me either. Sorry.
Yeah, I don't have that legislation, but I do want to circle back to what Secretary Zamuda said. I really like the idea of it being initiated by case managers. I also think there might be value, and of course this is the advocate in me, of the question being of the possibility of the question being raised by either prosecutor or defense counsel too. That basically either party should be able to raise that question to the sentencing court. I killed the discussion.
I personally don't. My feeling is, and I know defense attorneys are always going to advocate for their client, always going to want less supervision. I mean, that's just a fact, right? They want that's what their job is. So I don't like the idea of having the prosecutors making that decision personally. I think you've got to have the people that are trained and know how to deal with these individuals making those decisions.
So I'm not suggesting that they would make the decision. I'm suggesting that they could initiate discussion on it.
Yeah, I don't like that, but for the same reasons. And I understand where you're going with that, but I think, they're not dealing with these individuals day in and day out like our supervision officers are. They don't know what the issues are. And again, I think, they've got different motives on why they would want lesser supervision versus what actually makes sense for public safety and best interest of the offender themselves.
Yeah, this is Stephanie with CSG Justice Center. I would actually echo what Spence is saying for a couple of different reasons. Spence's points, definitely, but also I'm going to leave the defense attorney part out on my own end. But on the prosecutor side, I will say that in the focus groups that we conducted with chief CSOs, it was apparent that prosecutors also play a little bit of a role here in decision making and advocating for severity of sentence and things like that. And so having someone who's really familiar with the case, like the probation officer, case manager, really allows for what that defendant has accomplished over the last year or has not accomplished. Can speak to their behavior in general. And I think, that really leaves it open for them to bring forward and say, hey, they've been on community corrections for 9 months now. And in that 9 months, they have done X, Y, Z. And I know that they have this new case, but they've really done everything they need to do. And court services, which is maybe a less intense form of supervision, really would be appropriate for them to continue on, maintaining their job, not increasing their, contacts every week, having to leave work, things like that, arrange childcare, whatever the case may be, and allowing that probation officer or that case manager to kind of advocate for that, or to at least acknowledge that they think that person is ready for a less intense form of supervision, or may need a more intense form of supervision, is probably more informative than an, I don't want to say any attorney, but then an attorney may be able to kind of provide to the court, just with their limited access to a defendant.
Well, this is Sheriff Carr. Obviously, we can't account for all the scenarios which we come up against on a
Absolutely.
basis, but the clients, many of these clients we're speaking about are felons on most cases, so they're on probation or parole on a felony case, and they turn around and get maybe a second time DUI or a third time DUI. So you can look at several things here, or an assault charge or a battery charge, but just because they've already got, their criminal history's built up a little bit on drugs or alcohol or domestic violence. So there's a lot of scenarios that are going to play into this as well.
Absolutely, Sheriff Carr. This is Stephanie with CSG. I couldn't agree more. One of the things that I think we can actually can get into a sticky point, and I've seen in other states as well, is actually including too much detail in a statute. That can get you into a sticking point too. So too much ambiguity or too much detail can really kind of hurt those on the ground unintentionally.
Okay, it sounds like we have a general consensus among the subcommittee about severity of sentence being a good metric here, and we need to look a little more at some of the impact of that. But I'm going to suggest that we take a break in the conversation now. Is everyone available to meet on Monday, October 11 at noon?
It's a federal state holiday, Columbus Day. I will not be available that day. I think there are agencies that certainly work on that day, but I won't be.
Okay. I had not even thought about the holiday component of it. Let me take a quick look.
And while you're looking, Professor, just for Sheriff Carr, 216610 discusses transfer of supervision, and it simply states that supervision may be transferred from one district to another.
Thank you, Spence. How about Tuesday, the 12th at noon? Would that work for folks?
I have a subcommittee already that day.
Yeah, there's a diversion subcommittee on that same day.
Yeah, we kind of staked out Mondays for this group. And that was why I tried to stick with that. Let me take a look at, what about Wednesday the 13th?
Good with that.
That works for me.
I could make that work.
Okay. And Stephanie, will you be available on Wednesday the 13th?
I will be.
All right, then let's go ahead and continue this discussion where we left off on Wednesday, October 13 at noontime. And I will ask Natalie, please, to send around a WebEx link for that day. And we'll pick up the discussion from here. I think probably the next topic to take up will be addressing that second big question Stephanie raised, which is, how do we get the supervising entity to administer conditions that maybe they're not set up to administer, such as collection of fines for a different group. So you think about that in the meantime, and also take a look at these statutes too. Spence, thank you for finding that, or Sheriff Carr, thank you for finding that statute 216610 about transfer. We can take a look at that before then too.
Thank you, Spence.
All right, folks, thank you very much. Have a great week, and we will see you soon.
Thank you, everybody.
Thanks a lot.